Hello everyone, welcome to Court with Krissy. I was expecting the defendant to read a SovCit script on the record, but what happened next? So much better. Do you think the attorney's feelings got hurt? Let me know in the comments. I hope you like it. Court with Krissy is now in session.
Court calls now the matter of people of the state of Michigan. Terrence Patrick Wood. This is file 25-5019FC.
Brian Sigler on behalf of the people, Your Honor.
Michael Horowitz on behalf of the judge.
Thank you. And sir, are you Terrence Michael Wood? Patrick Wood. I'm sorry, Terrence Patrick Wood.
Yes, Your Honor, I am. I have a something I've written out here I need to read to you at some point.
I can't hear you, but let me see if I can fix that issue on my end. Can you say what you just stated again?
I have something I've written out I need to share with you at some point. I don't know if you want to ever hear it before or after or whatever, but.
Well, I'm not ordinarily in the habit of hearing written comments from attorneys or written comments from defendants that aren't shared with the court in advance because the law generally frowns on those. I'm probably going to reverse course and hear from you just for the sake of hearing what you have to say and so I can address it. But ordinarily what's required is that your attorney files motions on your behalf and then I address them or the prosecutor does. But I'm going to start by hearing a status conference update from the attorneys. Then I'm going to hear from you if you need to be heard and I'll decide how to proceed. So from defense standpoint, Mr. Horowitz, what is the update following our last hearing?
So Mr. Wood has previously explained to me that he does not wish to accept the plea offer that's been extended by the state. I've made the offer clear to him as I can in writing and in person. Although at our last hearing, he told the court that he's not receiving my mail. And again, I don't have any indication as to why or whether or not that's accurate. But he did repeatedly state that he wants to take this matter to trial. So I think it's just a matter of preparing for that. I'm not able to do that in this month. I would have to ask for at least probably another status hearing, just for reason of being occupied with another matter that's going with certainty at the beginning of June.
Well, there's no possible way I could have a trial in the next 30 days. And even if I had my staff notice it as soon as I can, I think the statutory or court rule requirement is 28 days notice. So even if I scheduled it and had time within the month, which I like, you're going to have more than at least that amount of time. If I get a trial date though and have my staff set it and indicate that it should be no sooner than say 30 or 45 days, is that what you're asking for? Is just a known amount of time to finalize preparations?
Please, Your Honor.
And let's start with the prosecution then. If we have a trial in this case, how many days do you expect it will take to try?
Your Honor, I think it's reasonably likely it would be done in one, but I would probably have 6 or 7 witnesses. I would ask the court to set it for 2.
Do you think 2 days is enough time if those 6 or 7 witnesses is called?
I think it's a 2-day trial.
All right. So before we get to that, I wanted to hear from the attorneys, Mr. Wood. Did you know that it was going to be your attorney's request to get this matter docketed for trial because you've rejected the plea offers that he went through with you?
I've only got one plea offer. Yes, I do reject it. Yes.
All right, but let me take a step back and then I'm going to allow you to be heard if you need to be heard. Mr. Ziegler, can you state the terms of the plea offer on the record?
Your Honor, the plea offer that Mr. Horowitz negotiated on Mr. Wood's behalf is that he could plead to 2 counts of possession of methamphetamine. In exchange, all other counts in the habitual offender for defense notice would be dismissed.
So 2 counts of possession of methamphetamine, each would be a 10-year maximum sentence, correct?
Correct.
And unless there was something that I'm missing because those offenses were charged at the same time, they would also run necessarily concurrent to each other.
That's correct, Your Honor, and I would add that I believe a condition of that plea that Mr. Horowitz had negotiated was that there would be a sentence within the guidelines as well.
Was that what you had negotiated, Mr. Horowitz?
That's correct, Your Honor.
And Mr. Wood, did you hear that?
Yes, I did.
So the plea that you're rejecting is for a plea to 2 counts of possession of methamphetamine, a suggestion by the attorneys that I would sentence you within the sentencing guidelines range, and that presumptively those would be concurrent or otherwise served at the same time. Are you aware of that?
Correct.
And are you aware of the nature of the charges that you're facing right now and the potential penalties?
I am.
You're aware of then, I'm sure, that maintaining a drug house, if you're convicted at trial as a habitual fourth, is a 15-year maximum statutory offense. Are you aware of that?
Correct.
You're aware that the controlled substance delivery or manufacture of methamphetamine are each 20-year maximum offenses typically, but because of the fourth habitual offense, notice they are life offense maximums. Do you understand that?
I do.
Delivery and or manufacture is also a significantly higher grid, meaning the guidelines ranges is going to be monumentally higher for a delivery offense as a habitual fourth than it would be for a possession offense with no habitual. Do you understand that?
Yes.
And do you understand all of the benefits and all of the risks and penalties associated with the totality of the plea agreement?
I do.
Do you have any questions regarding any of them?
I do not.
Is it your knowing desire to ask for a trial, knowing those risks and the benefits of the plea?
Yes, it is.
Is there anything else you think I should hear from you before I calendar this matter for trial?
Can I read what I wrote to you?
You can read whatever you have, but I want you to bear in mind, Mr. Wood, I said this to you last time, but it's probably important in this context to say it again. Anything that you say on this court record could be used against you. So you shouldn't talk at all about the underlying allegations that have been made. And you shouldn't talk anything about your strategy for the case at trial, because if you say those things, they could not only influence me, but they could affect you legally. Your attorney's also standing. He may wish to be heard, but ultimately, I'm going to let you speak if you want to speak, Mr. Wood, as long as you understand there are risks. Mr.
Yeah.
Horowitz.
Judge, I just wanted to add to the advisement you were giving to Mr. Wood. I did include this in a letter to him, but Mr. Ziegler and I had discussed the guidelines ranges, and as Mr. Ziegler calculated, as charged, the guidelines ranges for the deliveries with habituals are 84 months to 280 months.
84 to what?
280.
Okay.
And the two possessions without habituals, the guidelines range is 29 months to 57 months.
Okay, Mr. Wood, did you get that information, at least the recommendations or what the attorneys thought the guidelines range would be?
I did.
So do you understand at least what the attorneys think the guidelines would be for the possession counts would be 29 to 57 months?
Correct.
That's under the plea offer. And then if you were convicted at trial, the attorneys expect or suggest that they think the guidelines will be 84 to 280 months. Do you understand that?
I do.
And did you still wish to proceed to trial?
I do.
All right. Did you have a statement that you want me to hear from you, understanding that whatever you say could be used against you later?
Yes, sir.
Go ahead.
Your Honor, first, I probably should have said something before this. I'm extremely concerned how I am to be represented when my attorney, being 5 months into this case, has not asked me one question about the incident that took place. He has not asked me to give him a timeline of a rundown of events, or who the three people were that I supposedly sold drugs to. How do I know them? What is our relationship? Nothing. I find this extremely disturbing. I also feel that my attorney and the prosecutor have an odd relationship in that they both want to see how much time they can give me when one of them should be defending me. The only thing my attorney has really said to me about the entire case is how much time I'm going to get, and don't piss off the prosecutor.
Judge, I'm just going to interject. I don't feel like I should have to be subjected to this.
Well, your objection is noted, Mr. Horowitz, but I'm not going to stop Mr. Wood from expressing his concerns, and then I have to rule upon them.
Mr. Wood has stormed out of meetings.
Mr. Horowitz.
He has given me the
Horowitz,
word.
excuse me.
He doesn't let me communicate.
Mr. Horowitz, if I have to talk over you, you are going to be found in contempt, and I sincerely do not want to do that.
Apologies.
I do not want to have to do that. I'm going to give you a reasonable opportunity to respond. Mr. Wood is inserted, and it suggests that he has something that he wants to be heard upon. I'm going to let that be heard. Then I'm going to rule upon it after I hear from you. You will be able to be fully and fairly heard.
I'll just ask to withdraw. I mean,
I'm not granted anything, Mr. Horowitz, other than the ability to sit down plainly and calmly and then respond when given the opportunity to do so. You have been in the circuit long enough and understand the rules of procedure well enough to understand that when a judge tells you that you need to do something, you should do it.
I don't need to take abuse from this guy.
You need to hear what has to be said because you are the listed attorney in this case. That's the rule, and that's my rule until I release you from the case. So you can sit calmly in here. If you want to make a motion to withdraw later on the basis of that, it would appear that there may be grounds based upon a breakdown of the client relationship. But I haven't heard that motion yet. What I heard last month was your attempt to have a competency evaluation, which I went through and heard from Mr. Wood, and I denied it, but I told you it was without prejudice. You can bring those things up again, but the way to bring them up is not to object during his statement, and it's not to argue with the court when I tell you that we need to proceed. There's a way to do it, and you can do that later. Mr. Wood, you can continue.
Okay, one more thing. Second, I find it odd how this whole thing came about. My apartment is in downtown Kalkaska. I've only been there a little over a week. The entrance to my apartment is in the back alley between 3rd and 4th Street. My front windows overlook the municipal parking lot across from the post office on 4th Street. During the day, there is moderate traffic through the area. After 4 or 5 p.m., the only thing open is the Calhoun Restaurant Bar. My paperwork states numerous complaints were lodged, and I have to ask complaints from whom? I have no neighbors. I do not have people in and out of my house 24 hours a day at all hours. I would not tolerate it or put up with it. And if I were causing such a commotion or nuisance, the village police was right there. They watched the bar parking lot, which you can clearly see my apartment also. They would most certainly have come to my house and talked to me about it. I don't feel this warrant was issued. I think this warrant was based on lies and misleading information. That's all I have to say, thank you, Your Honor.
Mr. Horowitz, did you want to respond?
In the times that I've tried to discuss this case with Mr. Wood, he has stormed out of the room so I can't talk with him. He has yelled at me with profanities, with racial epithets, with middle fingers. And so I'd ask when I'm supposed to be able to discuss these things with him if that's how he interacts with me. I don't think it's a breakdown. I think he's incompetent. I think the things he just said are delusional, continue to be delusional, and that in the police report, he admitted the offenses. And now he's talking about something about the Calhoun and some complaints. There are like 3 or 4 people in the police report that report getting drugs from him or buying drugs from him. And he acknowledges and admits that. But now it's about the Calhoun. I mean, this is
Counsel,
it's.
I'm going to cut you off for a second for this reason. You, like Mr. Wood, are going to be able to make whatever full record you want to make today. I question whether or not you should be saying the things that you should be saying. It's up to you. You're the attorney.
I think he's delusional. I think he's incompetent.
Anything else you want me to hear?
No, I think he should have an examination because the things he said do not comport with reality, and they have not this entire case.
Mr. Ziegler, did you wish to be heard on this issue? Any of these issues?
Your Honor, I'm not privy to the communications between Mr. Horowitz and Mr. Wood, so I don't have anything to add in that regard. I would say that Mr. Horowitz and I have discussed the case repeatedly. He has expressed his concerns about his client to me in the sense that he was going to ask for a competency evaluation. I didn't oppose it. I would also note that Mr. Horowitz has negotiated what I consider to be a fairly favorable deal given the circumstances of this case. And I am quite surprised that Mr. Wood is not going to avail himself of that deal. And while certainly I can't say that someone's incompetent just because they refuse to take a deal, it does give me some pause, but I'm not privy to their private communications. I think if Mr. Horowitz made a motion to withdraw, I would probably support it given the communications on the record today, Your Honor.
Mr. Horowitz, is that your intention, is to file a written motion to withdraw?
You know, it hadn't been. I had felt that I was capable of representing him, but I don't feel like I should have to sit here and take abuse that's not founded on anything. And I feel that it's professionally threatening, and I feel like it's disrespectful. And I think that it very well may paint my interactions in the future with Mr. Wood such that I may not be able to represent him fully for fear of what things he will say or make up about me in the future.
Mr. Wood, did you have anything else you want the court to hear before I decide jointly between all of that information how to proceed?
Your Honor, he's talked to me like one time, and we never went through what happened that night. It's never been discussed. He's never asked me anything about it.
So the court has a hard time uncovering and unraveling what's happening in this case. Frankly, it's clear to me, Mr. Horowitz, that you're perplexed and upset by the things that are being said by Mr. Wood. It's clear to me that Mr. Wood, you appear perplexed by things that I'm saying in terms of the plea offers. On the one hand, you appear to tell me you understand clearly what the maximum penalties are. On the other hand, you appear to, perhaps as the prosecutor characterized it, it doesn't make a lot of sense that you don't want to entertain plea offers that reduce charges significantly. On the other hand, if you're not guilty of anything, you shouldn't take a plea to anything, and you should be willing to have trial. And so that makes sense as well. I'm not going to do anything right now. I'm instead going to choose the path of what I think is the best patient outcome. I'm going to adjourn this proceeding. I'm not going to change anything with the status quo in terms of setting a jury trial or otherwise making any substantive decisions about this case until we return at my next available date. If it's possible, Mr. Wood, for you to have discussions with Mr. Horowitz, you should have those. If it's not, then I'm going to expect when I come back next time, I'm going to hear from you and Mr. Horowitz that you two cannot communicate. And if that's the case, I'm going to have to seriously consider whether or not there has been a total breakdown in relationship between the two of you. If I make that determination, I have little option. And it appears, Mr. Horowitz, that you've made that determination already, but I haven't seen it by way of a written motion. If you are intending to ask me to relieve you as counsel, you're going to need to file that written motion. Mr. Wood, you have a right to be heard on that motion as well. If you agree with Mr. Horowitz's motion to the extent he files it, I'll hear from you next time when we're here. But ultimately, I'm going to have to make that determination. And once that determination is made, if I grant the request by Mr. Horowitz to recuse himself or be out of the case, then I'll have to appoint a new attorney. If I have to appoint a new attorney, I probably will need to give you time to get up to speed with that attorney. So beware of that and think about it, because I might need to give you time to be able to go through all the background with a new attorney if I appoint a new attorney. Anything else to create for purposes of the record today, Mr. Ziegler?
No, Your Honor.
Mr. Horowitz.
Thank the court for its patience and its even temperament, and thank you for sifting through this, and I apologize for my disposition and reactions. Thank you.
Thank you, counsel. Mr. Wood, anything else you want to leave us with before we see you at our next hearing?
I guess not, Your Honor.
We'll see you next month then. If I can do it, it will be in about 2 weeks. I just don't know what my next docket looks like. You'll get a notice in the mail at my next available date, however. Thank you.